Here's something that most business owners do without realizing the risk, and you just need to be aware of. A lot of times, LLC owners and business owners send proposals that accidentally become binding contracts. And so let's say you send an email that just says, looks good, we can start next week at $25,000. And then the opposing email responds and just says the words, agreed. That can absolutely be a contract. And legally, you only need three things: offer, acceptance, and consideration. And you have a contract. You don't need a 12-page document. You don't need formal language. You don't need signatures sometimes. And in a case like that email can represent a contract. Courts are looking at intent and substance. They're not looking at formatting. I have seen businesses get locked into pricing, scope, deadlines because of email chains that were meant to be quote unquote just discussions. And so here's some practical advice to make sure you don't end up in a situation you don't want to be in. If you are negotiating, say that clearly. Use phrases like subject to a formal agreement or a non-binding discussion. Make sure that's in your email. You can even have a signature line that says, we need a formal contract. If you are sending pricing, clarify whether it's a proposal or a draft for negotiation. And if you are not ready to be bound, do not write like you are. Do not try to push the limits to negotiate. Make sure it's very clear if you're negotiating or you're entering a contract. In business law, contracts form faster than people think. And once they form, you're not arguing about what you meant, you're arguing about what you wrote. And that's what the court wants to see. And that's a much harder position to be in if you don't want to be in that contract.